We will shortly have goodwill messages. Many have had very beautiful things to say about the book. His Lordship Justice Jones Doche, after doing the foreword, concluded by commending the book to us and then referencing that a quotation by George Washington that a knowledge of books is the basis upon which other knowledge is to be built. And so we all need the book to build our knowledge. I'd like to recognize the presence of Nana Obri Asamoah II from Obri in Ashanti. Thank you so very much for making time to join us. There are some of us who are still in masks, so it's been difficult to identify people you know who even sit close to you. Let's also welcome Justices of the Supreme Court sitting right in front of us, Justice Gertrude Tokonu and Avril Lovelace Johnson. Please of course. Abayate. Thank you all so very much. Shall we now have goodwill messages?
In land law and customary law. I am honored to tell you a little bit about Honorable Justice Osetutu in the Gambia and the work that he has been doing for us in the Gambia. I must say with sincerity that he is one of the legal luminaries in this jurisdiction. His judgments are perfect, his reasoning is sound, and I'm very, very honored and proud to be associated with the launching of this book, and I believe.
I am Honorable Justice Olede Oko Uduma, a High Court judge in the Gambia. I'm sending my greetings and solidarity to my learned friends, Honorable Justice Alexander Osai Tutu, a High Court judge in Ghana, and who is on secondment as a High Court judge in Gambia. Sir, congratulations. You are a great judge. You are an erudite scholar and icon. I've had opportunity to go through the wonderful piece you put down for our generation. That is the essentials team in land law and customary law. We are so much grateful. The work is an edifice of legal documents. I must say, it is not only for Ghana, it is for the world at large. It is not only for this generation, it is for generation others to come. I encourage all of us, including my humble self, to tap from it, to read it, to make use of it. Thank you, sir, for what you have done. It is a great work. I am saying congratulations, more grace to the elbows, and no feathers to the judicial wing. Thank you.
We have improved efficiency in the determination of land and customary matters. And so it will be an invaluable contribution to the many efforts that have been made to improve access to justice and the efforts to build confidence in the administration of justice. It addresses pertinent issues and reminds us, for example, that the right to possession of land is not always synonymous with trespass to land. It reminds us that we don't question enough our attachment to Western interpretations of our laws, especially our land and customary laws. It argues in favor of the concept of both to improve access to justice. it argues in favor of enforcement of prenuptial agreements, also to improve access to justice.
Please, round of applause for Justice Alexander Spetitu's friends and colleagues in the Gambia, where he presently does his work. We will, at this juncture, like to have some remarks by our guests of honor, and then we'll have the official lunch before we hear the spontaneous music man give us another interlude. Please, His Lordship Justice William Atuba will give us and then the official lunch.
Really overwhelmed by the duty cast upon me to make remarks about this book and to launch it. To confess, the book intimidates me because the load of them from anthropology to English law to customary, constitutional, everything. It's so, I've never seen a book so learned as this. The meticulous microscopic scope of his learning is very daunting. He even refers to Section A, Question 1 of the 2016 Ghana Law School Entrance Exam paper, which posed the question, who is the allodial title holder of land in the northern regions? Among them, he lists Naba as the chief, the Tindana, that's his target. And then he says that he is sure that most of the students must have said it was the Tindana. His research goes even to social media space, where he detected some argument going on between lawyers and the public as to the effect of land guards and caretakers. Impression being given that after a long time, these caretakers could acquire adverse title to the people who put them there. And he had to debunk this at length. There again, it shows that his research is limitless. Going to social media, anything that has something to do with the law relating to land law, he picks it up and deals with it. Of particular interest is his treatment of the allodial title as the very first chapter in the book. And after giving a resume of the nature of the allodial title in legal history, he comes up with his conclusion that the allodial interest is the mother of all interests in land. I recommend this as the most apt description of the allodial title. It means it gives birth to all other titles and interests. It's like the grown-up of Kelson, on which all other laws depend. He, however, takes issue on 3 grounds with the definition of allodial title under the prevailing act, the Land Act 2020. The definition, he says, is not progressive. It also has some omissions and is provocative of litigation. 3 principal criticisms of that definition. Now, his reason for saying it's not progressive is that governing expression, descriptive of the allodial title, refers to acquisition in the past. It mentions acquisition by the state, by conquest, by prior discovery and settlement, gifts, sale, and so forth. But because the expression is used in relation to this, that these are the most, with the title, may have been acquired. It says that, well, it's not progressive because it means it is not dealing with prospective acquisitions or current acquisitions of allodial title, but only looks to the past. But he says that there are other modes of acquiring the allodial title than what even Section 2 has stated, even in terms of the past. It refers to other modes like adverse acquisition by acquiescence, the allodial title. Said at first, under common law, it was not envisaged that the allodial title could be acquired by acquiescence, because writers like Arocha and Lodo and so forth say that it being the highest interest in land, it is inconceivable that another interest could supersede it. Any form of acquisition of interest could supersede. Well, I must emphasize that land is one of the most technical areas of the law. Very, very technical. But I'm happy that he has taken the position that since the decisions of the Supreme Court, beginning with Gayhawk versus Hannah, and that was decided in 2005 to 2006 Supreme Court Ghana law, followed by Jane and Musa also. And then the one he quotes at length is Agosai versus Nene Kobi Tetechu, which he quotes a passage from our judgment. And I'm sweating. Because it says that I said that the allodial title could from that time be acquired by acquiescence under common law as well as under the statute of limitation. Yes and no. As I said, land law is highly technical. Those who say that it is the highest and cannot be acquired otherwise to remain in the original owner are similar to those who say that estoppel per se can never be the route for claiming title to land as an established title. But he quotes from an English case where the court said, yes, long possession, all that, acquiescence and so forth, will not divest the allodial title of the original owner. But it says that, it ends up by saying that, but in effect, that's what it does. So, I feel healed by the semantics of that kind of reasoning, and support him in saying that, notwithstanding those technicalities, our position in Agosai versus Kobe Tetechu 2010 to 2012 Supreme Court General Report is the most realistic and up-to-date statement. He now goes on to talk about some other legal issues. I'll mention them in compendium. He lists out a number of errors, omissions, inconsistencies in most of the provisions of this act. They actually replete. For example, in defining land, or talking about the ownership of land, some provisions we talk about the stool, skin, family, clan, or group of persons. In reference to some of these things, some of these owners is omitted. And yet, there are duties which have been spelled out in relation to them. The question is whether the omitted ones are also subject to those duties and qualifications. Of particular interest is the position of the Tindana. I had the misfortune of having to write the judgment of the Supreme Court on who is the allodial title holder of land, or some land in the Upper East region. At the time we were encumbered with so many constitutional cases, but the case had pended for long. So we said, all right, we have to dispose of it. So we had a conference. We came to the conclusion that it is the Tindana. Those of you who are not from the north, the equivalent is land priest or Wulomo. Wulomo. The Ga version of it. And now I want to emphasize why a book like this should be of importance to every legal mind. I'm from the Upper East, and when I was growing up, I saw that the official called Tindana was performing certain rites in relation to land. Sometimes when there was a drought, the villagers would go and drag him on the ground to some shrine to make sacrifice. And they'll keep on dragging him until rain comes. That's all I knew about Tindana. But what his real powers were in relation, I had no idea. So, although when this matter came up, I, with that background, felt that no, it should be the Tindana. But what was the quantum of my knowledge about his landholding powers? Virtually nothing. I went to school too early, from age 6, thereabouts. So, the customary setting was not what caught up with me. Luckily for me, there was a very good article in the review of Ghana law written by Professor Ashite Kote. And when I read it carefully, I was encouraged that his analysis was right, that is the Tindana who has the allodial title for on behalf of the communities of at least the Upper East. He has clearly shown that the whole of the North ought to be the same as the Upper East position. That is, the Tindana is the repository of the mother interest. This is what I now use. Mother interest, which is the allodial interest. Now, before I saw that article, I suffered a narrow defeat in some land case when I was at the bar at Bolgatanga, because I was doing a land matter and I was contending, trying to analyze and to impress on the judge that the chiefs had no authority over land there. But then the material at my disposal was very scarce. My opponents went and took a certain book which recounted the case of Azantolo versus Nair, where it was held that the chief Azantolo had capacity to litigate lands, title to lands within his jurisdiction. So upon this, the judge was swayed, gave judgment against me. I was very aggrieved, but I couldn't blame him because that was the authority available to him. But Professor Ashite Kote analyzed that decision in his article in the Review of Ghana Law, I think 1980, Review of Ghana Law. So I was happy to have seen it, and I followed his reasoning. And he said Olenu was wrong in thinking that that decision made. So if I hadn't come across that article by Professor Ashite Kote, I would have been very, very hard-pressed to decide that matter. There were other writings quoted by Jan, who was counsel. So I'm saying that academic writings can be very, very important. First of all, they make your research easier. Imagine the number of law reports. Take just the Ghana law reports over all these years. If you are to find the law on a point and you have to read through all up to even the Supreme Court judgments alone, I mean, it will be a very, very burdensome task. And you can hardly inform yourself adequately of the law because the decisions are so many. And it will involve reading them as they are reported in the law reports. They are long. But writers like this will refer to all of them in a composite manner and makes it very easy. Well, apart from this allodial title matter, he talks about certain provisions of the Constitution or of the Act which can be unconstitutional. For example, the purported area giving some hand to the Minister for Lands and some other administrative authorities to double in the administration of land. Says if you look at the constitutional provisions, Articles 267, 167, thereabouts, all this, and you match them against these provisions, they cannot stand constitutionality. An area of interest is spousal property. He says Parliament was supposed to have enacted legislation to spell out spousal property rights, but they did nothing until the Supreme Court had to say that, all right, in the meantime, in Mensa and Mensa, the divorce case, the impression was that property acquired during the marriage was presumed to be jointly acquired and to be shared equally. I must confess that I felt uncomfortable when When I heard this, I think I was on the panel. I said, hey, this one. All right, another time. Maybe you can always distinguish in the practice. I don't think that, you see, Africans, we must always go the full length of whatever the whites are doing. You know, some of our own practices are backed by common sense. Realism. I'm happy that
see how the men are.
In subsequent cases, I think Patson and I was on that one. Then Finn and others. Subsequent ones, they sought to limit the wide scope of Mensa and Mensa. And particularly, some of them said, look, we cannot override Articles 18 and 12, which uphold fundamental human rights to individual property ownership. And so, yeah, because otherwise, why should I, by reason of amorous adventure, in care forfeiture, partial or otherwise, of my bona fide acquired property, how lawyers suffer to make their money? You go and bring somebody who has not sweated much because of certain attractions. Now, I want to emphasize that fundamental human rights shouldn't be joked with. And I think this is the second time I refer to this anecdote. When we were in the law faculty, I was made to illustrious Chief Justice. Now, the ladies were accustomed to working together, and we the men too. Not quite together, but not also with the ladies. One day I was passing by, and she and Akoto Bamfu and I think Alote and another were walking. Then she particularly asked me my idea about women. So I said, oh, well, they are good for discotheques and the kitchen. Maybe I added some other thing, maybe not, but it was necessarily implied from what I. So she said, oh, come on, foolish boy. But I was most grateful because she gave me the opportunity to express my candid view about the status of women. You know, those days, I mean, we're youngsters, we would think in those terms. I was very, very happy that I expressed myself. So, spousal rights must be looked at subject to Articles 18 and 12. It's not only substantive law that he deals with the procedure too. For example, the mode of bringing actions or defending actions by families and stools. He insists that under the procedural rules, CI 47, as amended, it is the head of family or the occupant of the stool as well who can sue and be sued. But long before that, those provisions were there in LN 140A, 1954 legislation, I think. But with time, the courts enunciated the principle that, these are corporate bodies, so they can sue and they sue companies. So whether a head of family came and suing as such, or it was just the name of the school or family they entertained. But I said that's not correct. And I think that he is right. The courts cannot just overrule legislation. You know that procedural rules, breaches can be, waived. Order. Okay, they can go under that, but not just to push aside the provisions. When the waiver is given, the breach, the innocent party has to be placated in some cost. But that's not what has been happening. He also talks about land guards can get injunction to protect any threats to your property and all that. But the procedure, is it by motion or by writ? He has dealt with them at length. There are many other things, but I think 5 minutes is gone. So all I'm emphasizing is that this book is most thoroughly written and is the most current because it's based on the latest Land Act. You cannot just, this is the best, most current book because whether you like it or not, you cannot hope to study the land law, the horse, the provisions of the Land Act. And he has based himself squarely on his analysis. And so when you read his book, you are well equipped as far as land matters are concerned when going to court or giving advice, whatever. This judge reminds me of some eminent judges of England, of Ghana. I'm sure we all want me to start with Lord Denning, no? He came later. There was one particular judge, high court level, whom even the House of Lords feared, Devlin. Very thorough, very brilliant. He is black, but I think some DNA may show some connection. Genetic connection with Devlin, because he's of that stature. We also know of Lord Atkin. We know of Lord Denning. In Ghana, Apalu, ACCRA, and Co. are there. And it is fair for me to confer on him a praise that the English judges bestowed on Lord Macnaghten because of his learning. And they said that his name was one that was clarum et mirabile nomen. And so I compare that upon that note. I'm now going to launch. And taking a last ditch at his learning, which permeates the whole of this book, the purpose of today's function. He has taken he has made a remark that the area decisions under the common law, beginning with Ohimen Aje, Oleno, and so spelling out the most of acquiring the allodial title, have been the principles there have been somehow misconstrued or misunderstood, because he says Oleno did not exhaustively state them. He said he was talking of the principal modes. It means other modes also there, not excluded. This is how brilliant the mind was. For me, I've been reading that thing but not taking it up. Without more ado, before I quote the passage I used to launch, I have to say in his favor that he does not claim to be perfect or to have all the knowledge of the law. In fact, one English judge said, God forbid that one judge should know all the law. And so he says, he quotes an Ewe proverb that knowledge is like a baobab tree, and no one person's hand can encircle his gift. So some of his views, though cogent, can permit of comments. For example, his idea that because Section 2 defines the allodial title in a retrogressive manner, therefore it appears nothing can be done. It's using expressio unius as expressio as clusio alterus to close all most of the doors to any incursion. The issue arose, and it was Francois J.R. Sedans who wrote the judgment that for the purpose of compulsory acquisition of land, the expression that was used, may by instrument, didn't mean must by instrument. And so it didn't exclude other modes. So I think when here they are talking of may have acquired, not saying that the only way. Also, we must always remember that no statute should for any reason be construed as to produce an absurdity. God can always avoid that by giving it construction that avoids that. That said, I now quote the part I want to use to declare this book launched. Everybody who has been given a chance to write a note or endorsement of this book has acknowledged the brilliance and the learning, etc. But of all of them, I think the most apt is the observation of Professor Ernest Kofi Abochi, who says, and I quote, "Undoubtedly, the book deals with themes that are carefully selected in terms of currency, relevancy, and utility to lawyers, judges, lawmakers, law students, and members of the public. This great work must certainly be read by everyone who is determined to appreciate recalibration of many areas of Ghanaian law in contemporary times." So on this note, we hereby declare this very famous and learned book duly, fully, and passionately launched.
Please keep clapping, keep clapping, keep clapping.
Thank you very much.
Help me welcome my very good friend, Catherine Hay. Catherine Hay. Our friend Tia says that as a legal practitioner, your brief may not be as good as you may want it if you ignore this quote. It's a legal circle. And Yahweh also says that my Lord has brought his forensic approach to application of laws in an erudite manner. We all need this. Yes, Kafu.
Thank you very much, Samson. Good evening. All right, thank you very much. We've had so much from all the esteemed speakers, and it's now my turn to speak and extract money from your purses and your wallets, your pocketbooks, the checks. For a worthy cause, launched essential themes in land law and customary law. I know no Latin, I know no law, but I know how to speak and get the job done. So I have 3 rules in my auctions. So the first rule is, if you're not buying, you're clapping. Which means that if somebody buys, then you clap. Is that clear? If you're not buying, fantastic. The second rule I learned, okay, has somebody bought already? Feel free to interrupt me and then make a purchase, I don't mind at all. The second rule is that, see, my teachers in this auctioning and fundraising business, they are the hawkers on the streets, who are very alert to hand signals and even eye signals. So you're driving, you're concentrating on the traffic and you're looking straight ahead, but your eye just moves to the right and then they're there by your car. Yes, they want to sell something to you. And so I'm very sensitive to movements of hands above your head. So that if you raise your hand over your head, I will assume it's a buying signal and I'll come by. Yes, so that's it. It doesn't even have to be your hand. Eye signals, eye movements are very, very critical for me. So at this point, people who know me start discovering that they have messages on their phones. So that my eyes don't catch their things. But it's okay, I'm used to being ignored and abandoned by my friends during the auction, after which our friendship resumes. So it's not a problem at all. The third and final rule in my auctions is that betrayal is allowed. What do I mean by betrayal? Betrayal is if you know somebody who can buy and the person is seated to your right or your left, you can just and I'll come over. We're gonna make this fun and we're gonna support justice. To just make this a big event for him. Okay? I won't take too much of your time. 20 minutes we are done and then we are good to go. So we have a mobile money number that you can save on your phone right now if you want to support us. It's star 718 star 25 star 1235 hash. Star 718 star 25 star 1235 hash. That's for the mobile. We take cash, we take checks, we take all currencies. Bank of Ghana is not here, so don't tell them. I can take dollars as well, and euros. And so, without much ado, with the permission of the chair, I want to start my auction. I think I'll descend and be closer to where the money is. And I'm not too worried about the curtain drop for a little bit. Give me carpet. Yeah, some carpet, some. Yeah, that's it. Put your hands together for Ken. He's great. I'm not too worried about a slow start because we're Ghanaians. We're like the Black Stars. You know, Black Stars go to competitions. They don't score. They don't score. The first game, they don't win. They may even lose the first game. Second game, they may draw. And then the third game, the calculators come out. they start calculating how many goals we have to score, what is Cameroon doing for us to get to the next round. So if you don't respond after 5-10 minutes, I want to worry. That's why we have music. The music will help us to support the good justice. You go to shops like Max Mart and Koala, ShopRite, they always play music. And I went and asked them, well, why do you guys play music when we are buying? They say it helps you to buy some more. So the music is here, great musician, giving us a great instrumental music down there. And I want to take a first offer. Yeah, let's support the justice very well. We've got various packages. We've got platinum, we've got diamond, we've got gold, we've got silver, and I think I'm going to start with the platinum. So I'm looking for 20,000 cities to support the good justice for not just one book. We're going to give you multiple books, so that you keep one in your library and then donate the rest to other lawyers or law students or your former law school library or up-and-coming lawyers, law students, everybody. 20,000 cities for multiple copies of the books, and you're going to have other things as well. Their t-shirts, their mugs, what's inside? Diaries, pens, yeah, key rings. Yeah, it's big. So you can come together. If you decide that 4 of you want to contribute and support the justice, that's fine. I'll give you enough books for you to have one each in your library, and the rest you can donate. So I'm looking for an offer of 20,000. You can donate by law firm, by law class, by law school, as an individual. And don't worry, those are my friends, I've seen you. And you can look at me, I'll just acknowledge you. Listen, there are also anonymous options. So if you decide that you don't want to let us know that you are giving, I can come to you and I'll take your details quietly and then we'll do it. And I can tell you one thing, in every auction I've been to, the anonymous donors give the most. So you can decide to be part of them. Alright? Okay, so we have a couple of very few platinums, and by the way, there are very few copies of these books left today. So we want to make sure that you leave here with a copy. The Justice spoke very highly of the book. Supreme Court Justice spoke very highly of the book, and I think you should be getting a copy. So we're looking for a couple of platinum offers. If there's any action happening behind me, let me know. Feel free to, or you want to figure, right? We are looking for 20,000 cities for a platinum copy of the books. Any 20s in the house?
Looking for 20,000 who will be number one. Talking about land and customary laws. It is important, come I know you will succeed. You will be surprised even by the action.
Thank you. Any 10s in the house? Any 10,000s in the house? 10,000s, 20,000s, 10,000s. We want to support the justice. It's a full house. I haven't been to a butch. This is a platinum. Okay, right. It's quite heavy.
It's suggest that group
God has suffered too much. It's quite heavy. Alright? Please help her to lighten the load. 20,000s, 10,000s, any offers, let me know. We'll give you multiple books. We have a hand up. Please look for me. Look and find out. If you're not buying, you're clapping. Somebody's buying you. Please clap. Starting everything off with the 10,000 CDs if you're not buying your class. Thank you very much. 10,000. Alright, we have a 12,000 here from. Give us Herman, 12,000 CDs. Give us Herman, 12,000, we have 22,000 CDs. Any more? Please feel free to go higher than what I've asked for. I asked for 20, I got 10, so we gave me 12. Any more offers, we're still platinum. So we have a 10, we have a 12. Thank you very much, Gilbert. Thank you for the Rock Chambers. Any more 10s in the house? Any more 10s in the house? We're happy to take your offers. 20s. Please let's make sure givers get his books. Any more offers in the house? We have any more offers? Platinum, we're giving multiple books. 10s, 10,000, 20,000. 85s in the house. 85s in the house for us. 5,000 CDs. We have a couple of fives. If you not give you a clap. So we got 5,000 CDs from the Right Honorable Speaker of Parliament is paying us hot cash. Alright, thank you. Let's send the Speaker's representative right here. 5,000 CDs. Thank you very much. We'll make 27. Let's try and get 100,000. Yes. The justice deserves it. Okay. I'm coming over to you. Yakma Marketing 5,000. So we got 27. So Yakma. Raise your hand. So we have 32, but 5, 5, 10, 12, 32. All right. Assemblies of God, 5,000 CDs. If you're not by yourself. Assemblies of God, please, let's come here. Assemblies of God. We have 37,000. 37 is the hospital. 37,000. Any more 5,000 in the house? Any more 5,000s? We welcome more 5,000s in the house. Thank you very much. You're doing well. Deputy AG, 5,000 CDs. We have 42. Thank you. Deputy Attorney General, please serve me right there. And then Assemblies of God, especially the front of there, 5,000. We have 10. That is 42. Any more 5s in the house? Any more 5s out? Please bring the books plenty. We got plenty 5s. Melenate and Samoa the 5th. Another 5,000 CDs. We got cash. So we have 47. Thank you. Another 5,000 here. Any more 5s in the house? All right. Gary Nemanko of Manfo and Associates. Another 5,000 if you're not buying your clapping. All right. There's one here. Right here. Please, let's serve him. And there was a cash here. Yes, and there's 5,000 here as well. Yes. So that's 52,000. Please serve him. Please serve him. 52. Any more 5s in the house? Any more 5s? More 5s. Oh, Law school class of 2002, they're taking me back to 10,000 CDs. 62,000. Thank you. Law school. The law school class of 2002. 10,000. Okay, so we're at 62. Let's get to 100. Come on. All right. Dr.Kwabena.com, 5,000. Right here. In the corners, wearing the nice snazzy tie. Okay, so we're at 67. Anyone? Just raise your hand, I'll come to you. We're at 67,000. Let's get to 100. At least. This book is a big book. Unique book. Law school. 2002. Yeah, now follow me. Law school. Yes. of 2002 have just so clearly demonstrated, showing you have 20 years after they graduated and they're supporting with 10,000 CDs. You know what flies in the house?